We'll continue on the theme of labor law with our next speaker. That is Mr. A.Sarveswaran, who is senior lecturer at the Faculty of Law here at the University of Colombo. And he teaches labor law at both the undergraduate and postgraduate levels, and is director of the Master of Law program and course director for labor law at the Faculty of Law at the University of Colombo. He's also coordinator and senior lecturer for postgraduate studies in the area of conflict and peace studies at the Faculty of Graduate Studies, also at the University of Colombo. Sir, the floor is yours.
Good morning. My presentation is on contract of employment in Sri Lanka. A contract like any other, but a contract not like any other. So when it comes to the employment sectors in Sri Lanka, we can divide into three categories. One is the public sector, other one is the semi-government sector, the third one is the private sector. So this presentation becomes relevant to the semi-government sector and the private sector. This is a hypothesis. Conduct of employment is insignificant in employment relationships in Sri Lanka. These are the objectives. So I will be focused on the main aspects of my presentation. So I will commence my presentation with the first part of my title, that is contract of employment is a contract like any other contract. When it comes to a contract of employment, it is a contract or an agreement between two parties, employer and employee. Letter of appointment could be considered as a contract of employment. So here the two parties agree on the terms and conditions of their employment. If there is any violation by one party, the other party can go to a civil court and seek civil remedies from the civil court. Here, when it comes to the first part, it is a contract like any other contract, because it is simply a contract between the two parties, employer and employee. So I am going to move to the second part of it, that is the crucial part of this presentation. It is a contract, but not like any other contract. So the first part is a contract between the two parties, employer and employee. They agree, but they only have their letter of appointment. The second contract, like other contracts. So when it comes to the second part, it is not a contract like other contracts. Why? The welfare state recognizes the unequal bargaining power between the two parties, the employer and employee. Therefore, the state intervenes to protect the employees, the weaker party, from exploitation by the employers. To protect the weaker party, the employees, the state has enacted many labor legislation. There are about 40 labor legislation. This 40 labor legislation deal with the matters related to employer-employee relationship. This 40 legislation cover most of the aspects of the employer-employee relationship. So therefore, very few matters are left to the parties to decide. When it comes to those few matters that are left to the parties also, then there are issues. In Sri Lanka, we have labor courts, special labor courts with just and equitable jurisdiction. When it comes to the labor courts are different from the traditional courts. The labor courts are not bound by or not fettered by the contracts of employment. If the contracts have unreasonable clauses, the labor court can simply ignore those clauses and make just an equitable decision. So, I said, when it comes to the labor legislation covers most of the aspects of employer-employee relationship. There are few things left to the parties. When it comes to those few things that are left to the parties also, again, the labor courts can ignore them if those clauses are unreasonable and unjust and unacceptable. Therefore, when it comes to contract of employment, I say it is not a contract like any other contract. So when it comes to labor legislation, if any contract is against the labor legislation, then the contract is illegal. If it is legal but unreasonable, again the labor courts can ignore them and make just an interpretation. So that means the labor courts are again not bound by the clauses in a contract of employment, even though the clauses are legal. So the other one is, the previous speaker mentioned on this collective bargaining and all. Outcome of the collective bargaining is collective agreement. If there is any conflict between a collective agreement and a contract of employment, what is in the collective agreement will override what is in the contract of employment. So that is the. So when it comes to these three developments, that is the labor legislation, the other one is the special powers of the labor courts to ignore the contracts of employment. The third one is the overriding collective agreement. So the status of the contract of employment will diminish. There are many ramifications from these three developments. One is non-written forms of contract. When it comes to a contract of employment, there is no legal requirement to have it in written form. It could be in informal form. Sometimes the contract between the parties may say that it is not a contract of employment. It is a contract for some other form of contract, maybe agency. But still the labor courts can consider the facts of the case and decide, no, it is a contract of employment. So here the labor courts create a contract of employment without having a formal contract. Implied terms of contract. So the labor courts can implant implied terms into contract of employment. When it comes to industrial arbitrator, when he makes just and equitable awards, the awards become implied terms of the contract of employment. So the labor courts create contracts of employment and also the labor courts can implant terms into the contract of employment. The next one is contra profundum rule. When it comes to contra profundum rule, suppose if a contract has a clause which has two meanings, or there is any ambiguity, then it should be interpreted in favor of the employees, not in favor of the employee. So the contract, this rule also makes the contract which is more favorable to the employees. Again, when it comes to termination of services, the labor courts, labor tribunal has power to hear the cases related to termination of services, not termination of contracts of employment. Why? The termination may be according to the contract. So the contract says the either party can terminate the contract by giving 3 months notice. So employer has given the 3 months notice. But still the labor courts can consider the case, hear the case and decide whether the termination is justified or not. The labor tribunal will not see whether the termination is according to the contract or not. So that is a matter for the civil courts. But when it comes to the labor courts will not see whether the termination is according to the contract or not. The labor court will see whether it is justified or not. See, termination, whether it is according to the contract or not, is a matter for the civil court, not for the labor courts. Then settlement out of course. It is always welcome to have settlement out of course. But suppose if the settlement is unreasonable, still the labor courts can ignore the settlement out of court. Because they have just and equitable jurisdiction, they have to make just and equitable remedies. In that process, if they find those settlements are not acceptable, then they can ignore the settlements out of court. But when it comes to the traditional courts, they accept the settlements out of court. They are bound by it. But here labor courts are not bound by it if the settlements are unreasonable. Then variation of contractual terms. So when it comes to the variation of contractual terms, if it is a unilateral variation, the labor courts can simply ignore it. But even though it is a consensual variation, but not reasonable or unreasonable or not just or equitable, then the labor courts can say, even though the variation is a consensual variation, because of the just and equitable jurisdiction we have power to interfere or intervene or ignore the consensual variation. So the labor courts have that power also. So all these developments make the contract of employment different from other contracts that we have. So that is why the Supreme Court has recognized the concepts of common law that give prominence to the rights and duties of employees under their contractual terms are no longer applicable in our legal system. But it doesn't mean contract of employment is not a contract. It is a contract. That is the first part of my topic. The contract of employment is a contract, but not a contract like any other contract. So, my conclusion is this. The labor codes, the labor legislation enacted by the parliament, the labor codes with just an equitable jurisdiction, the collective agreements, all other developments from these three have made the contract of employment different from other contracts. So here the labor codes can create a contract of employment without a contract. The contract may say that the contract between the parties may say that it's a contract for agency or for some other purpose. Still the labor codes can create a contract. At the same time, they can also destroy the contract and make the contracts invalid. So in that context, I would like to conclude my presentation by saying it may be confusing, but it's a contract. Contract of employment is a contract, but it is very much different from all other contracts that come under the civil law or before the civil courts.